Before continuing with the witness statement by the defense, the Chamber doesn't want to give the impression that it does as if nothing had happened on Friday. We don't want just to go back to business as usual without pointing out some things. We don't want, in other words, continue with the trial and the witness testimony giving the impression that we do not realize really what happened. And therefore, the Chamber wants to make a statement and 2 recommendations. The statement is as follows. What happened on Friday afternoon, just before the adjournment of the hearing, and I'm referring to the closed session ordered by the Chamber, which leaked out, is of utmost and inexcusable gravity for which the Chamber, but I would say the whole ICC, apologizes first and foremost vis-à-vis the persons whose name were unduly made public. That in order of such sensitivity, like the one to go from open to closed session, in order to discuss issues which obviously should not be revealed to the general public, is not implemented, is of such gravity that the Chamber has ordered an accurate internal investigation in order to find out how this could have happened. And therefore, we don't know yet if the reason for this is recklessness, superficiality, stupidity, and I don't even want to speculate about something else. But we are waiting a detailed report, which, as I said, was given the order to draft to. The first recommendation is more of a legal nature, because it is an offense. It sounds a little bit strange that I say this now after what happened on Friday, but still, I'm cognizant of that. But it is an offense against the administration of justice, pursuant to Article 70 of the Rome Statute, for anyone to do anything intentionally that would amount to corruptly influence a witness, obstructing or interfering with the attendance or testimony of a witness, or retaliating against a witness for giving testimony in a case pending before the court. And apart from any specific provision in the Rome Statute, conduct such of those may amount to contempt of court under customary international law or general principles of law is recognized by the civilized nations, recognized as a source of law applicable before this court also under Article 21 of the statute. In the result, any revelation of the identity of a witness whose identity has been protected by this court amounts to an offense to this court. So too will any attempt to engage in any such revelation. The Chamber reminds, therefore, everyone inside the courtroom, in the public gallery, in Côte d'Ivoire, and anywhere else, to do nothing that would reveal or continue to publish and so reveal or attempt to reveal the identity of protected witness. The reason for such conduct is immaterial. So too the manner of gaining access to or arriving at or gleaning such information. Members of the press bloggers, social media members or participants, and their web hosts are particularly called upon to desist from anything that would reveal or attempt to reveal the identity of protected witnesses or to engage in secondary dissemination of such wrongful and illegal information. The second recommendation I will want to make is more a didactic one, may I say, with more a moral background than a legal one. The ICC is a court of law, is not a political arena. What we are doing here is serious, is a trial based on precise legal provisions, on rules, on regulations to ascertain if the accused are innocent or are guilty in relation to precise facts they are accused to have committed. The laws, the rules, the regulations we apply in this court, in this courtroom, in this trial, are recognized by the international community and this is even more important, are recognized by Côte d'Ivoire, who has ratified the statute and therefore recognized the court and the law which this court applies. But in order to be able to apply the law, to reconstrue and understand the facts we are dealing with, and to take at the end a free, and I repeat, a free and an informed and hopefully right decision, we, the judges of this chamber, we need to analyze documents, but we need also to listen to what persons who lived these facts, who saw them, who participated, come to tell us. These persons, the witnesses, are per definition not against and not in favor of the accused. But they are persons who are obliged to come here and to tell the truth, nothing but the truth. And we, the judges of this chamber, have to understand and to assess what they have to say in order, as I said before, to take this free and informed decision. Therefore, I call upon the ethical, but even more above the legal, the ethical obligation, especially of journalists, to well balance their right to inform, which is absolutely one of the rights of journalism, but the right to inform with their obligation, with their responsibilities, to inform correctly, not to put in danger people, and by not informing correctly, maybe also to ignite the atmosphere. So I really ask all the people to calm down. We don't want to ignite anything. We just want to do the best possible our job. All of us, we are sitting here in the courtroom, and the observers should be very cautious on what they are doing and how they are expressing and disseminating the news which are coming out from here. So I think we can let it now awaiting also the report. And I asked the court officer to call the witness so we can continue our work.